Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been several new developments in the Idaho4 defamation case styled as Scofield versus Guillard. We have been following this case for the past couple of years to its conclusion, which was the jury trial that was held the last week in February of 2026, where a federal jury returned a $10 million verdict in favor of plaintiff Scofield in Scofield versus Guillard and against the defense, Ashley Guillard. This case is directly related to the tragic and catastrophic events that occurred at 1122 King Road on November 13th, 2022 in Moscow, Idaho, when 4 University of Idaho students were found unalived in a rental home located steps away from the Moscow campus of the University of Idaho, which is where Scofield is and has been a professor of history. The defense is an online content creator, TikToker / psychic and tarot card reader. And what the plaintiff alleged is that she was defamed by the defendant, who made certain public statements about her, alleging that she had involvement in the events at 1122 King Road. After that jury returned the verdict, on March 5th, 2026, the case came to a conclusion when Judge Patricchio, the federal judge, entered a final judgment in the exact amount that the jury awarded, $10 million total. There have been 2 categories of items that have been filed. Number 1, the first motion to set aside that final judgment, which the defense filed on April 6th, 2026, asking Judge Patricchio to vacate, to throw that final judgment out the window. We're going to come back in a future episode of the Indie Zone to go over that packet. What we can tell you at this point is that the plaintiff has an opportunity to be heard in the form of a response, which is due April 27th. The other event that occurred post-judgment is something that we have been looking for, which is a notice of appeal, and that was filed by the defense on April 6th, 2026. And what it does, it now invokes the defendant's right to have an upper court look at this case and determine whether or not it should be reversed, that final judgment, and effectively thrown out, or if it should be affirmed. The notice of appeal was filed in district court, exactly where it needed to be filed, within 30 days of that final judgment. So now we await an appeal opened up. This is in the Ninth Circuit Court of Appeal. And when that happens, then it will be up to the appellant, and that's what Ms. Guillard will be in the appeal, to lay out in her initial brief on the merits her facts, her evidence, and her legal authority why this final judgment should not stand. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.